Hello everyone, I am Anuj Nakade and you're watching LiveLaw. LiveLaw is an online legal news portal that brings you news from courts all across the country. We are able to sustain our operations only with the constant support of our readers, viewers and subscribers. So to help us bring you legal updates consistently, please subscribe to our channel and share this video. Today, we bring you more news from the Supreme Court regarding the most pertinent issue before humankind, climate change and the environment. Yesterday, on the 26th of April 2023, the Supreme Court passed an order regarding eco-sensitive zones or ESZs. This order was passed in one of the country's most important environmental cases. The case itself is a public interest litigation filed by T.N. Godavarman, which is very popularly known as the Forest Case of India. The case was originally filed by T.N. Godavarman all the way back in 1995 to protect the Nilgiri forests in Tamil Nadu. The case has since expanded over the years to include a number of forest and wildlife related issues across the country. The case is still ongoing under what is called a Continuing Mandamus. A Continuing Mandamus is a very rare type of case proceeding through which the Supreme Court designates itself to oversee the implementation of its own orders. You may have heard of the Jain Hawala case, where this Continuing Mandamus was issued by the Supreme Court as well. As it happens, T.N. Godavarman versus the Union of India is one of the most important and the longest running examples of a Continuing Mandamus in the country. This is because of how important the issues of environmental protection and ecological balance are. The Supreme Court issues orders from time to time to ensure that the conservation of forests is done as per its directions in its orders. One such order was passed by a 3-judge bench of the Supreme Court comprising Justice L. Nageshwara Rao, Justice B.R. Gavai and Justice Aniruddha Bose on 3rd of June in 2022. In this order, the Supreme Court had mandated a 1-kilometer eco-sensitive zone around protected forests and wildlife reserves as a buffer zone. However, because of population explosion, many human settlements have come up very close to these forest areas, even inside the eco-sensitive zones. Because of the strict directions of the Supreme Court, lives have come to stand still in these places. An ecologically sensitive zone is basically a place designated by the government to safeguard biodiversity and is not allowed to be exploited for commercial purposes. The Union government now approached the Supreme Court to modify this order and allow certain activities such as building permanent structures in the 1-kilometer radius of the ESZs, in respect of which draft and final notification issued by the Ministry of Environment, Forest and Climate Change. A 3-judge bench of Justice B.R. Gavai, Justice Vikram Nath and Justice Sanjay Karol heard this matter. The court noted in this proceeding that the requirement of declaring ESZs is not to hamper day-to-day activities of citizens, but to protect forests from negative impact and to refine the environment around protected areas. The court had observed, and I quote, "If the direction as issued by this court in paragraph 56.5 of the order dated 3rd June 2022 is continued, then no permanent structure would be permitted to come up for whatsoever purpose in the aforesaid ESZs. As already pointed out from the aforesaid examples, hundreds of villages are situated within the ESZs in the country. If no permanent construction is to be permitted for any purpose, a villager who is desirous to reconstruct his house would not be permitted." The court has also said that if this direction is continued, it will also intensify conflicts between humans and animals, which is not the intention of the order. The modification could be a relief to these settlements as it allows the construction of roads, schools and dispensaries by the central and the state governments. The court has, however, held that any mining activity around the area of 1 kilometer from the boundary of a national park or a wildlife sanctuary shall not be permissible. That's all we have for you in this video. If you found this video informative, please leave a like and tell us in the comments if you would like a more detailed video regarding this very important case. We will also leave a link down in the description below to the full order and the article for your ease of reference. Don't forget to subscribe to LiveLaw for these updates and hit the bell icon for notifications. Thank you.